Judge Fowl continues, however, as the Court of Appeal held in Blockbuster Entertainment Limited v James 2006, IRLR 630 CA, this power is not to be exercised readily. 5. Ellipsis. The two cardinal conditions for its exercise are either that an unreasonable conduct has taken the form of deliberate and persistent disregard of required procedural steps, or that it has made a fair tribunal. Sorry, I'm so exhausted. I've not slept for like 30 hours. Or that it has made a fair trial impossible. If these conditions are fulfilled, it becomes necessary to consider whether, even so, striking out is a proportionate response. This has indeed been a deliberate and persistent disregard of required procedural steps, such as attendance at a hearing or providing an address to the tribunal. The fact that direct communication between the parties is impossible is itself. I think he means in itself, surely. An extraordinary feature of the claim. But the overriding concern is about intimidation of the respondent's witnesses, which directly affects the potential fairness of any hearing. Provision of address in compliance with tribunal order. Contrary to the tribunal's assertion, I provided my current address in compliance with the unless order dated 17th of June 2025, and this information was confirmed to the respondent. Denying that I complied constitutes a misrepresentation of the facts and demonstrates apparent bias. Providing an address in line with tribunal direction satisfies the procedural requirement under Rule 3 and Rule 47.2 of the Employment Tribunal Rules of Procedure 2013, which obliges the tribunal to consider any legitimate explanation for non-attendance or procedural concerns. Proportionality under Blockbuster Entertainment Limited v James 2006 IRLR 630 CA. The Court of Appeal in Blockbuster made clear that strikeout powers should not be exercised lightly and only where there is deliberate and persistent disregard of required procedural steps or where fair hearing is impossible. Here, the tribunal has misapplied this test, as the alleged breaches, attendance and address provision, were either non-existent or fully remedied. My provision of the address, combined with legitimate requests for remote participation due to safety concerns following retaliatory arrests and stalking, or alleged stalking, I might have to say, demonstrates reasonable compliance, not deliberate disregard. Allegations of intimidation misapplied. The tribunal cites concern over the alleged intimidation of the respondent's witnesses as affecting fairness. These claims are factually misleading. The respondent and their associates, including Chris Robshaw and Camilla Kerslake, orchestrated repeated harassment, witness intimidation and defamation against me, including the dissemination of over 50, now 95, national press articles. I, as the claimant, did not engage in unlawful conduct towards witnesses. The tribunal's framing inverts the reality and unfairly portrays me as the aggressor, contrary to Rule 3 and Rule 38(1)b of the Employment Tribunal Rules of Procedure 2013, which requires fairness and impartiality. Fairness of hearing maintained. As I had provided my address and submitted repeated communications requesting remote access, there was no persistent procedural breach and no obstacle to conducting a fair hearing. Striking out the claim in these circumstances is disproportionate and procedurally unsafe, failing the proportionality test highlighted in Blockbuster. Conclusion. The tribunal's reasoning misrepresents both the facts and my compliance. There is no deliberate or persistent procedural breach, and concerns about witness intimidation are misapplied and biased, rendering the strikeout decision unsafe and justifying appeal.